On Monday, the 14th of July 2025, at the end of a lengthy trial, you were both convicted of killing your baby daughter by gross negligence manslaughter. On the 23rd of May 2024, in the first trial, another lengthy trial, you were both convicted of concealing the birth of your daughter, perverting the course of justice, and child cruelty. You must now be sentenced for all those offences. The facts. Between 2017 and 2022, you had 4 children together. In the autumn of 2022, it was clear you decided that with a 5th child due, you would become itinerant. You then moved between addresses frequently with the clear aim of ensuring that no local authority would have jurisdiction over you, such that they could take steps to ensure that your 5th child was taken into protective care. You had available to you significant financial resources. Constance Marten, you were the beneficiary of a discretionary trust that provided you with a significant income. There was evidence adduced that over a 4-month period between the 1st of September 2022 and the 3rd of January 2023, payments totalling £47,886 were made to your bank accounts, a monthly allowance that increased from £500 to £3,400, as well as larger payments, including £13,596 said to be for the purchase of camera and filming equipment on the 17th of November 2022, and £15,590 said to be for the purchase of a car on the 22nd of December 2022. The precise details of the birth of Victoria, as you were to name your daughter, are known only to the two of you. It may well be the case that she was born in Woodcutter's Cottage, as you have both claimed. But as much of what you have said at different times cannot be relied upon, it is not possible to be exact. What is known is that the birth took place before the 5th of January 2023. On that day, the car you were driving caught fire, and when the fire had been extinguished, a placenta was found. When it was found, you had abandoned the car and made your getaway. Not only did you leave the placenta with the car, you left a vast quantity of other items, including baby clothes, a passport, personal belongings, a quantity of cash, more than 30 mobile phones, and a live cat. What then occurred over the following days was you travelled long distances using taxis, crisscrossing England between various ports. Whatever your ultimate plan, your paramount concern seems to have been to avoid detection and to get abroad, although without any passport for either of you, or indeed the baby, that may have been very difficult to achieve. In my judgment, it is clear that throughout the period from the end of December until your arrest, neither of you gave much, if any, thought to the care or welfare of your baby. Your focus was on yourselves. The period 2017 to 2022. Back in 2017, you were both given the clearest of warnings about the perils of living with a newborn baby in a tent during the winter months. You had also been warned of the risks of unsafe co-sleeping. A brief review of the history of events with your other children displays an arrogance and lack of thought for anyone else other than yourselves. Whilst you have both sought to paint a picture of being caring parents, both in this court and in the course of the family court proceedings, as even the material set out in the agreed facts that both criminal trials amply demonstrates, the actual position was very different. The family court judge described the nature of the relationship between you as being obscure, and one that involves serious physical violence perpetrated by Gordon on Marten that gives an obvious and significant risk to a newborn being caught up in a similar incident. Returning to the sequence of events, in early 2023, after your car catches fire on the M61, you flee the area before embarking on travelling long distances by taxi, with the travel focusing on ports. The evening of the 5th of January, you are seen in Bolton at the railway station, wearing clothes that are clearly soaking wet. At that stage, other than what you are wearing, you have little, if anything, by way of belongings for yourselves, or more significantly, for your newborn baby. You travel to Liverpool. After a very short time there, it is another lengthy taxi to Harwich, where you arrive in the early hours of the 6th of January. You are in and around Harwich that day and in the port area on the 7th of January when you are spoken to by Dale Gosling. Mr. Gosling spoke about hearing the baby crying. As he was to describe it, it was the cry of a clearly distressed child. Later that morning, you take another taxi to Colchester before moving on to East Ham. Although you claimed the baby was dressed in a ski jacket and normally carried in a sling, where there is video footage, it shows the baby clad in little more than a simple baby grow and not in a sling. On the afternoon of the 7th of January, Gordon, you resorted to putting plastic bags over your shoes, no doubt due to how wet your feet and shoes have become. You acquired a tent and sleeping bags. A buggy was bought but soon abandoned before you travelled to the south coast. The taxi driver is told to head to Portsmouth before then being asked to divert to Newhaven. You are dropped by the taxi driver just before 5 a.m. on the morning of the 8th of January 2023 and are seen on CCTV heading towards open fields on Cantercrow Hill. In February, there are sightings in the area of Hollingbury Golf Course and Seaford. And on the 27th of February, a visit to the shops to buy food led ultimately to your arrest. Turning to the cause of death. The death of your baby was the result of the obvious neglect by you as to the real needs of your baby. In my judgment, as Professor Haveneth clearly demonstrated through the tests he conducted and presented at the retrial, your baby was exposed to significant cold stress. I propose to sentence you on the basis of death by hypothermia. Whether it was by that means or by smothering may not make any significant difference when it comes to sentence, but my clear conclusion is that the appropriate basis for sentence, in the light of all the evidence, is death by hypothermia. After her death, you concealed her and perverted the course of justice. A high-profile and labour-intensive national search and police investigation led eventually to the discovery of your daughter's decomposed body in a supermarket bag for life, filled with rubbish and left abandoned in a shed on an allotment. When you were arrested, neither of you was prepared to give any assistance to the police about the whereabouts of your daughter's body. Your silence at that stage of events is highly significant. If, as you have both sought to claim, this was a terrible accident, why not alert the authorities then, and why, once arrested, not say where the body was to be found? You claimed you wanted dignity for your baby's body, and yet your conduct displays the complete opposite. In the course of the trials, you have both sought to put the blame on everyone else, on the police for the hunt for the baby, and you on members of the public. You've claimed some have made up what they said or did in their presence. For others, you suggest all they wanted was their moment in the limelight. What your attitude completely fails to acknowledge is that it was the safety and well-being of your baby and the two of you that was paramount concern to the police and to members of the public. To most right-thinking people, their children are the most precious beings, to be nurtured and cared for, to be kept warm, to be fed, even at the expense of parents' own comfort, and above all, to be loved. What you did towards baby Victoria, despite all you claim to have done, can only be described as neglect of the gravest and most serious type that led ultimately to her death by your gross negligence. On the facts here, this was continued offending in the face of obvious suffering to the deceased. There is clear negligent conduct in the context of other serious criminality. In addition, there is blatant disregard for a very high risk of death and the concealment of the body. Those are all factors listed under culpability B. I have taken into account all that's been put forward by the prosecution and on your behalf on this issue. In my judgment, this case is one that falls within very high culpability. Looking at the factors present that I have set out, very high culpability is amply demonstrated by the extreme character of your blatant disregard for a very high risk of death resulting from your negligent conduct. There is also the very considerable impact of concealing the birth, perverting the course of justice by hiding the remains of your daughter so as to frustrate a proper examination of the cause of death to hide your own shameful conduct. I have already referred to resources, but you had the financial means and the opportunity to raise your daughter in a safe environment, and you chose not to do so. In my judgment, concealment of the birth, the death, and how the body was then treated really do speak for themselves. Moving next to consider any other factors increasing seriousness. In your case, Gordon, there are the previous convictions recorded against you. The older convictions are for extremely serious offences, and the conduct in Wales in 2017 is relevant in the context that the offences relate to events around the birth of your first child. In 1994, in America, for armed kidnapping, armed sexual battery and armed burglary, you were sentenced to a lengthy prison sentence. Those offences date back to April 1989, when you were 14. In addition, there are convictions for armed burglary and aggravated battery from May 1989, also when you were 14. You were convicted in 1994 and sentenced to 40 years imprisonment. You were deported to the UK prior to serving the full sentence. In 2017, there are convictions from the Carmarthenshire Magistrates Court for 2 counts of assaulting a constable and 1 of failing to comply with your sexual offender notification requirements. You were sentenced on the 14th of November 2017 to a total of 12 weeks imprisonment. This incident took place in the maternity ward of the West Wales General Hospital. You and Marten attended the hospital giving false names and identities as Marten was giving birth to your first child. When police attended the hospital and questioned you, Gordon, about your identity, you gave a false one. You then began to pace the room, stating that you were confused. You refused to sit down and leave the room. When officers tried to stop you, you assaulted 2 female police officers. Eventually, you were brought under control when Parva was sprayed, and with the assistance of a member of the public who was on the ward. In my judgment, there has been no genuine expression of remorse from either of you. Whilst there have been expressions of sorrow about the death, throughout you've adopted the stance of seeking to blame everyone else other than yourselves for what happened. Sentence. On gross negligence manslaughter, in your case, Mark Gordon, there will be an extended sentence of imprisonment amounting to 18 years, with a custodial term of 14 years and an extension period of 4 years. In my judgment, Gordon, in your case, the dangerousness test is met. I've given consideration to the provisions of Section 285 of the Sentencing Act 2020 and whether the seriousness of the offence or one or more of the other offences associated with it was such as to justify the imposition of a sentence for imprisonment for life. However, I do not find it to be. There will be the extended sentence that I've passed upon you. Marten, in your case, as the dangerousness test is not met, there will be a determinate sentence, a sentence of 14 years imprisonment. In your case, I've given consideration as to whether the custodial sentence should be of the same length as that passed in respect of Mark Gordon or not. Having reflected on the issue, I am of the view that the custodial terms should be of the same length. The issues around future risks have led me to the conclusion that Mark Gordon should be the subject of an extended sentence, and there is therefore that distinction between the two of you. On count 1, concealing the birth, the sentence in each of your cases are ones of 18 months imprisonment. Count 2, child neglect, the sentence in each of your cases, again, ones of 18 months imprisonment. On count 5, perverting the course of public justice, the sentence in each of your cases are ones of 5 years imprisonment. The sentences on counts 1, 2 and 5 are to be concurrent to each other and concurrent to the sentences on count 4. Gordon, in your case, what that means is it's likely you will serve 2/3 of that custodial term that I've imposed. If released at the end of that custodial term or at the 2/3 point, you will be on licence until the expiry of the extended period of licence in your case. Marten, in your case, you will serve 2/3 of the sentence I've imposed and then be released on licence. Released on licence, you are subject to the terms of that until the expiry of the custodial term.